Good evening, everybody. This is Omar Serrano with the Tilted Lawyer podcast. And we're going to go through, I might be by myself. I'm probably going to be by myself. Cassidy was going to join, but I'm pretty sure I'm willing to bet that she's probably asleep because she's severely jet lagged from her globe-trotting ways. And so that's fine. It's going to be just me for tonight. I had mentioned earlier when I was on Lauren's when I was trolling her in the chat, that I was going to try to get through all of the leaked evidence and, text messages, deposition transcripts. Yeah, that ain't happening tonight. There's just no freaking way I'm going to get through those hundreds of pages. I thought that I'll go through that. We're going to have some time. We got this MSJ to get through, and I'm going to recap some of that. Now, I wasn't there. It was in New York. Lauren Knighty was there. There was a host of other content creators that were there. Andy was there. Not Actually Golden was there. Little Girl Attorney was there, and a host of others whom I've both met and not met before. But I thought that, and if you haven't seen it yet, that Not Actually Golden and Little Girl Attorney, both of whom I've never seen do a live before. Like, I've seen like various clips of them before. But I had never actually seen a live stream. They actually did a really, really good job of breaking down what happened at the hearing, what Judge Lineman's impressions were of the arguments, what their impressions were of the attorneys. And based off of that and watching Lauren's live stream, I took some notes and I made some predictions. And, the spoiler alert is my prediction is essentially this. I think what's going to come of the motion is that I feel like the sexual harassment complaints, the sexual harassment causes of action are going to go away. I think they're going to get dismissed. I think Judge Lyman was pretty clearly zeroing in on very specific things. And there are things that the Lively attorneys and Lively herself are not going to be able to reconcile in terms of the elements. And Judge Lyman seems to be on board with the proposition that if you can knock out any one of the elements for sexual harassment on any of these complaints, then as a matter of law, it's gone on motion for summary judgment. And the questions I thought that he asked were not really the kind of things that you can overcome, because some of his reasoning is based on Blake Lively's own testimony that I didn't know existed. I don't know if it was a shocker, but part of the reason why she believes that she was sexually harassed, there's been a lot made of the birthing video. There's been a lot made of Jamie Heath storming her trailer to cop a look. It turns out in sworn testimony, she wasn't bothered by that at all. And she didn't think that Jamie Heath was actually doing anything wrong. She gave some testimony to try to make it seem as though she was bothered, but whole in part, I didn't see this coming. But based on what everybody is saying, Judge Lyman really zeroed in on the subjective element of sexual harassment. Like, it's one thing to be reasonably offensive to a lot of people. Like, for example, if somebody were to call you a derogatory name and use the same, name against me, chances are I probably wouldn't get offended. Therefore, I'm not subjectively offended, but you might. And that happens a lot. And so therefore, if I'm not offended, then there's no cause of action there. And so even if Blake Lively was to be able to convince a judge that what happened to her was, by a reasonable person's standard, severe and pervasive enough to hold that cause of action, if there's evidence to suggest that she did not subjectively agree at the time, contemporaneously when the event happened, then that complaint is dead in the water. And that's where he was going with that. And so upon hearing that, I was like, well, then what are we doing with this? What a monumental waste of time. And I know I'm kind of jumping the gun. I'm going to get through all my notes. I took a lot of notes because it's really the best I could do. I didn't get to go to New York. I had a serious case of FOMO this morning, and I never have that. I had a hearing this morning, and I come back, and then Lauren is live. And I knew that she was going to New York because, she was texting me about it and telling me that she's at the courthouse and they've taken her phone. And so she has to take notes the old school way on pen and paper, and remarking about how nice the federal courthouse was and how there's so much more people here than the Laura Owens thing that she also attended. And so I knew that was going on, but I heard her go live and give her summation of it. And I just, man, it would have been nice to have been there. And I saw a lot of other content creators there, most prominently, not actually Golden, whom Lauren keeps telling me about, whom she really likes, who I keep seeing these clips of. And I've never had the opportunity to meet her or consume her content. And a little girl attorney who I see all over the place, who Lauren has told me all kinds about for like the last couple of months. I just haven't had time to consume her content either. But after Lauren's, I got directed to their live stream, and they went on for about 3 hours, and they were fantastic in the way that they broke it down. I could see why people like them. Really, really good. Completely different. I don't know if there's completely different angles, but they gave a really good perspective on their analysis of the law. I was really, really impressed. I wasn't expecting that high quality. I had no reason not to expect high quality, but it was really good as all. I was impressed. It had me thinking like, wow, I gotta pick up my game a little bit. Look at these folks. Because they gave just a sterling analysis. What's up, folks? But yeah, they were really good. And so a lot of what my notes are based off of is what Lauren told me and what I was able to observe on that live stream this morning. But based on what seems to be the prevailing sentiment of various content creators that were there and just heard the arguments, I really feel that sexual harassment, it was a shaky cause of action to begin with. There were major concessions, it seems, that were made by Lively's attorneys at the arguing of the MSJ. And I just don't think that Judge Lyman is going to be able to bridge the gap between the deficits in their arguments and being able to cure what ails them to have it survive an MSJ. I think they're done. I think they're done with that. And so my prediction is that's going to go away. The breach of contract stuff, there's still some things to discuss. I mean, obviously there's a lot of other things, spoliation, whether or not there was other issues. I forget the territorial issue. I forget what that was. I'll look at my notes. There was that issue that they had to deal with that wasn't so clear. I think that if the only thing that we're left with is contracts, causes of action, I don't think this is going to trial. It's just not worth it. For what? Because the moneymaker aspect of this case for Blake Lively is that she was a victim of sexual harassment. She has undergone intense public scrutiny on the basis of, look, I don't think of all the people that follow these cases, and there are hundreds of thousands of you, if not millions, of all the people that follow this case, I don't think anybody really gives a shit about the contract stuff. They were brought here because of the salacious allegations made against Justin Baldoni. And the reason why the general public took to this case so the way that they did is because Blake Lively said some things, and then when it came to looking at the receipts, it did not look like it went down the way that she said. And then all these other narratives started to come out. It's like, wait a minute. Justin Baldoni is this guy who has this reputation in the industry, who has gone about the business of trying to promote women's rights and standing up for women's rights and making a movie about domestic violence. And she's trying to smear that guy. But then you add in the wrinkle that it was suspected that the whole reason why these allegations came about was because they were trying to steal the movie out from under him. And then you had a narrative that stuck. You had a hook. And then the public was in. And they've been in. And because Blake Lively has carried on this way, not offered not a single modicum of an apology, not backtracked not one iota, except in her sworn testimony, go figure. The fact that she's trying to prevail and go out in public and present herself as this victim of sexual harassment and promoting female rights, survivors of domestic violence, a lot of you who are actual victims of sexual harassment and domestic violence and sex crimes in general, were deeply offended by that. And so the ire that she faces from the general public And the reason why I believe this case has been so gripping has been like, wait a minute. So you can take these claims. These are the claims that we're spending $1 million a month litigating. And then we had to have discussions about 47.1. It's like, wait a minute. So if somebody wants to just bring some bullshit sexual harassment claim under the CRD in California because of 47.1, that's protected, such that if you try to bring a counterclaim because you're trying to claim that the allegations were defamatory in nature or retaliatory in nature, therefore treble damages, that hardly seems fair. And then very early on, we made the comparisons like, what about like the Tyler Perry case where he actually is a billionaire? Blake Lively, in comparison to Tyler Perry, doesn't really matter. But who Blake Lively is in this industry versus Justin Baldoni, I mean, the names recognition is highly disparate. Her earning potential is up to the filming of this movie has been highly disparate. And so she comes in as the bully, goes in and takes the position as if she's a victim while acting as the bully, trying to steal the movie out from under him. And Baldoni's over here floundering because he has no recourse. And now he's facing treble damages because he truthfully, in his mind, believes that Blake Lively brought these allegations maliciously against him. There's a lot to dissect there. And so we've been talking about this case for over a year now. We're into 2026. I first heard about this case at the end of 24, going into 25. I mean, that's when the CRD was about, I think, December 31st, if I'm not mistaken. But we've been talking about this case. And I remember so many content creators when the initial complaint drops, like, well, I guess we'll see. That's a lot. Those are some hefty allegations. And to Baldoni's attorney, to Friedman's credit, he did not wait. He did not wait to file a response. I don't think he waited very long before he launched the website, basically exposing all of the receipts, saying, look, this is what they're saying, but this is how it all went down. And it was just a web page of, I don't know how many gigabytes of evidence, but people could see for themselves the communications that took place, the timeline that existed, the emails, the evidence. We could see in real time what it was that Lively was talking about. There was actual video of some of these events where she characterized it one kind of a way, but the videotape showed a very different story. We got to see what the nudity writer entailed. We got to see the 17-point letter. We got to see the communications about and from Ryan Reynolds about how he was trying to actively bully Justin Baldoni because of whatever perceived jealousies, or he just didn't like the guy, maybe. I don't know. But I think the general sentiment when people sat down was like, holy shit. These Hollywood moguls are 100% trying to steal Justin Baldoni's movie. And then some of you guys took it a step further. Some of you guys put together that Blake Lively has had this project in mind since about early 2023, where she had conjured thoughts about this being her franchise. She wanted to turn this into a franchise, into a $1 billion entity, and profit off of it, off of the creative works of Justin Baldoni. And you could say that, oh, well, he stole it from this other guy. Whatever, man. I don't know nothing about that. I just know that what has come out and the prevailing sentiment seems to be that it wasn't her movie, and she actively tried to steal it out from Justin Baldoni. And then all of the concessions. And that's where we get to the contract stuff. So many of you pointed out, but she didn't even sign the contract. And then I kept pointing out, but they were there for a reason. They were certainly there for financial gain. They certainly did make a movie. They certainly did act based on a script that had guidelines and objectives and goals and rules and nudity writers and contracts, signed or unsigned. They certainly acted as if there were agreements between the two of them. Not to mention Sony, not to mention the Wayfarer parties, not to mention everybody else. There's a lot of moving parts with all of this. And so the contract stuff is always going to be like, we got to figure out what four corners of the contract are. And we don't know that because we don't exactly have a signed agreement. And it complicated things because every time Blake Lively had a complaint, she would make her displeasure known. And then like 100% of the time, the Wayfarer parties would cave to her demands, like every single time. And the judge kind of touched on some of that stuff today in the MSJ, and that's going to go to the contract stuff. Regardless of what I think about Lyman's opinions about the contract causes of action, I think that there's enough there where if we really want to do this, we can take that to a jury. If you guys want to argue about what the contract stuff was, that's the nerdy aspect of this case that nobody really wants to discuss. Even not actually Golden and Little Girl Attorney were like, yeah, well, contract sucks. Yes, it does. And then I had made the comparison that contract law, it's like the thing that everybody nerds out on when they're in law school, like when they're a 1L, and then like they just move on and do something else. It's like the equivalent of like a freshman that's introduced like to the philosophy class, and all of a sudden they're philosophizing everybody and like regurgitating Descartes and trying to convince everybody that they're this enlightened person, but they just read like 20 pages of, I don't know, pick your philosopher of choice. That's what contracts is. It's a lot like that. And you geek out on it in your first year. And after that, it's like, contracts kind of is what it is. It's its own beast. Let me make, before I get too far deep into my analysis, Khaleesi Direwolves with the 5. Good for 1. I can't see what that emoji is. What is that, a fish? Man, what is that? My wife is here watching. What is this emoji? It's a roll of toilet paper. Hope the kiddos feel better. It looks like a fish, but I'll go with that. I don't know. I can't see. The unsolicited opinion says, Omar, I think there is someone behind you. I tried to get the chat to convince that Lauren that her hotel was haunted. It didn't work out because she saw my comment. It's like, hey, everybody, while Lauren's not looking, let's all try to convince her that her hotel room is haunted. And then she looked up, was like, yeah, Omar, it's totally haunted. Well, she saw my plan. It's not the first time I did that. I also severely trolled her in her chat, just returned the favor because she's always trolling my chats. And so I thought it was only fair. Ricardo, what's up, bud? With the $2, been waiting for your input. Oh, I got plenty. I got plenty. MCH High Life. Can we vote Blake off the island yet? Sure. Let's do it. I'm down. Which island are we on? Which island are we voting her off of? Oh, there's Lauren 90. Your mom is haunted. My mom is haunted by many things. If you ask her, she's definitely haunted by the ghost of my grandmother. So how about that? All right. So let me get into the crux of some of this. I'm not going to do the thing where I go through all of the unsealed evidence because I downloaded it all today and it's like hundreds of pages. And yeah, that wasn't happening. Not today anyway. I just thought it would be more productive to do this. And so that's what I'm doing. So the first thing they talked about was the hostile work environment. The way that it was framed is Lively's team identifies 4 on-scent incidences. They talked about lack of consent during an unscripted kissing scene, and Judge Lyman really was not impressed with that argument. To the point of, and some of you guys have made so much of a deal that he's got a brother that works in the industry that's like a movie producer or whatever. I feel like it kind of helps in this aspect because look, creative folks have to be given room to create. And the nature of being creative is letting things happen, letting things unroll. Very seldom does a creative person have it all just right here and then just throw it on the page and it just comes out perfect. Look, man, things happen off script, and it is those unscripted moments that make the best content. And that goes for books, that goes for poetry, that goes for writing, that goes for public speaking, that goes for a lot of things. But he made the point, it's like, look, okay, you can't just say because it wasn't specifically scripted to the centimeter of the movements that every single time he went a centimeter off script, that constitutes a breach of your consent. If that's the case, like, we'll never get out of here. Everybody's going to have Basically, I think the point that he was making is sexual harassment loses its meaning if we're going to proceed by technicalities. The nature of sexual harassment is not a technical definition. It's not a math problem. It's very much subjective and objective. Objective to the reasonable person. Like if I were to describe what I subjectively felt, if you reasonably believe that if it happened to you, that yeah, I could see how that's sexual harassment. But if you say that, look, you're off like a centimeter here, automatically strict liability, sexual harassment, that's not the way that that works. And if that were the way that that works, well, that sucks. Who would ever make a movie? There's way too much liability to get yourself involved in something like that. That doesn't make logistical sense. It doesn't make common sense. It certainly doesn't make any legal sense. And so that's a huge problem. There was another thing. They contended that there was gender-based conduct because Lively is a woman, and therefore she's covered by anti-discrimination laws. I think she had to say that because of the FEHA stuff. They argue that there was at least 3 incidents of egregious sexually charged or invasive conduct that basically obviated the need for them to have to show a pattern of conduct. It was so egregious by itself, there was no need to demonstrate a pattern, which is problematic because it makes their argument weaker. And secondly, there's nothing that's come out in a year of litigating this case that has ever demonstrated anything that I would consider severe and egregious. I mean, what, Jamie Heath tried to cop a look while she was breastfeeding, showed her the birthing videos. Justin Baldoni went off script a little bit on some of the intimate scenes. And what was the other one? I'm forgetting one. Oh, was the personal trainer stuff? He got her a personal trainer stuff that specialized in weight loss. That was sexual harassment. What are we doing? What are we talking about? What specifically do you mean? There's nothing, not even alleged, that I've ever heard that would rise to the level of severe and pervasive enough that would obviate the need to demonstrate a pattern of behavior. Nothing. And if that's what they were relying on, if that's what they really argued, then Jesus, this sexual harassment claim is dead in the water. And we haven't even got off the ground. By the way, it is a Woodford night. I got some Woodford double barrel oaked or something. I've never had that specific brand, but it's delightful. Obviously, the defense disagreed. They maintain that, first of all, the conduct that they're complaining about was part of acting and directing. There was no personal advance. There was no breach of consent. There was nothing that was out of bounds. There was nothing that happened, in the dark corridors of the acting department or whatever, or in a trailer somewhere. Everything was out in the open. Everything was on film. Judge Lyman, according to Not Actually Golden and Little Girl Attorney, they pressed counsel on that. They said that, look, if Baldoni is the director and they're directing the character and they say sexy and hot, is that okay? And then counsel conceded, yeah, that's okay. It's like, well, then what the fuck? Then what are we doing? Like, was there anything else? Like, there was a hot comment in there. There was a sexy comment in there. And then if you read some of Justin Baldoni's transcripts, like there was even an instance where he suggested that I wasn't even talking about it in terms of like she looked good. I just said that she looked hot, as in like she looked like she was hot, like sweating because of what she was wearing. I don't even recall, but just that it reminded me of that. Are we even sure that that was used for sexual attraction? And that's kind of, I wish that I had that lined up, Baldoni's transcript. But yeah, he was saying that, look, I wasn't trying to say that she was hot, like attractive. She looked like she could use a glass of water. She looked like she was really hot. The set was hot. She's wearing this thing, and it looked like it was uncomfortable. That's completely different. Defense relies on context. Yeah, context matters. They were talking about touches in service of a scene or costume direction. That's not harassment. They were talking about the incidents, well, not severe and pervasive. And it's certainly not because of Lively's gender. They pointed out there was a portion of Lively's testimony, and this was kind of the crux. where she denied feeling harassed at the time that the incident occurred. And I think what they were talking about was Jamie Heath. She testified that she was not bothered, and she knew that Heath wasn't trying to look at her naked, even telling him, "I know you weren't trying to cop a look." And I'm like, then why in the fuck is that in your complaints? After all of that, like, why did you not voluntarily dismiss would be my argument. My next statement is like, if that's what came out in deposition, and maybe it was appropriate for MSJ, look, there's been so much talk about why the Wayfarer party's attorneys have been so quiet. And I had offered this suggestion that, look, they are litigating like a group of lawyers that have a winning case. And when you have a winning case, sometimes silence is the game plan. If you don't have to tip your hand, then why would you tip your hand? If you're just going to MSJ the complaint anyway, then who cares? And on the other hand, you have Blake Lively's attorneys, and they're at any and every opportunity trying to request sanctions for this and sanctions for that and discovery violations, and not giving in to requests for discovery extensions, and just trying to make it as difficult as possible for the Wayfarer parties, for Friedman and gang to litigate this case. Yeah, that's because they're trying to bully them or discourage them into continuing, maybe bully them into a settlement. It's a common litigation tactic. It just works better against lesser equipped attorneys, I guess. But I guess the tell was, if they're continuously asking for sanctions and telling Judge Lyman about every stupid little thing that they have imagined or conjured that the Wayfarer parties have done wrong, that is a sign that they know their case is 100% bullshit. And there was a reckoning coming. And it turns out it might have been, at least for the sexual harassment stuff, part of this motion for summary judgment, because they don't have much to stand on. There was even I remember a little girl attorney saying, or no, Naturally Golden, she made the point that Judge Lyman had asked them about the FEHA stuff. Why do you guys need this? Like, it felt redundant. And then they came out and said, well, because we could recover more damages. There was not a factual basis for it. It was pure strategy. And that's been their deal this entire time, hasn't it? I mean, take it all the way to the Van Zandt stuff, if you want to. I had remarked while I was in that live, just commenting, because they had mentioned that Van Zandt never got mentioned in the motion for summary judgment. My point in saying that was, if they were going to do anything with Van Zandt, it was going to be in a motion prior to the motion for summary judgment. And the only thing they were going to mention Van Zandt for was to try to exclude evidence of that was obtained through that bullshit subpoena, right? The Doe defendant lawsuit that they used to get that subpoena, which presumably led to fruit of the poisonous tree evidence. And they effectively laundered evidence by the sham lawsuit. That was the Van Zandt thing, right? And they didn't bring any of it in, and they didn't even mention it on motion for summary judgment. And as far as I'm aware, there wasn't even an evidentiary motion regarding it, because who gives a shit? They didn't get anything of value for their lawsuit anyway, and so they just didn't need it. But I'll tell you what did happen. There was a lot of folks that said a lot of things, and now that I look back at the pleadings, and now that I consider all the times that it was brought up and mentioned, they were always really coy about it. Like, they would never mention Van Zandt or the Van Sham thing for anything other than, I feel, to troll Lively and her attorneys. If they ever mentioned it, it's like, yeah, the Van Zandt thing, like they would never concede that, yeah, we're not going to use it because we don't need it. But they would all just throw out these little tidbits here, these little red herrings, and they would get all in a huff. And then content creators like such as myself, I'm sure I did like probably 2 or 3 lives based on evidence laundering and dissected the sham lawsuit. And I know other content creators did that as well. It was a huge red herring, it seems like, because they don't need it. And the only reason you bring it up, okay, maybe sanctions, whatever, fine. But really the reason you bring it up is because you're trying to exclude evidence. But you don't need to exclude evidence if they don't have any damning evidence against you. Who gives a shit? Let them believe that they got one over. Let them believe that they're winning. Let them believe that we're incompetent. Let them rely on that. And then when push comes to shove, we're going to motion for summary judgment the shit out of their causes of action, because they don't have any solid evidence to stand on. And the overwhelming sentiment that I'm getting from everybody that witnessed that hearing is that Judge Lyman is not buying the sexual harassment stuff. And that, in a nutshell, is why sometimes when you have a winning case, you shut the F up. And you let people think whatever they're going to think. You let them wonder why you're not doing certain things. Maybe they got something else up their sleeve. Maybe they're going to pull it out for this and that. Let them prepare for the thing that you're not going to do. They're only wasting their own time and energy. And you're sitting there and you know the answer to the equation. And what you actually know, and ultimately should be comforting to you as litigators, is the fact that you have a winning case and you know the strength of the evidence against you is like slim to none. Like they literally have her giving testimony that said for Jamie Heath, yeah, I know he wasn't trying to do that. It was fine. Then they said I was sexy. It was fine. I didn't think that Jamie Heath tried to cop a look. I was not uncomfortable by Jamie Heath. There's something to that effect. It's like, oh shit, that's kind of game, set, and match, is it? To the point where, and I didn't see it. I didn't see it coming. But if Judge Lyman is harping on Blake Lively's subjective observations, her subjective feelings towards the conduct, he's basically saying that you don't even believe this shit. Why are we here? Which gives rise to the proposition that if she doesn't even believe this was sexual harassment, or she wasn't actually sexually harassed, then perhaps she brought these claims for retaliatory or bad faith purposes. And does that shield Justin Baldoni from potential 47.1 treble damages? Maybe. My bigger question was, if sexual harassment does not survive MSJ, does it make it a moot point? I kind of think it does. Maybe. I'm sure they're going to argue, well, the letter of the law, they were unsuccessful in their counterclaim against our SH claims, and so therefore. But there was a caveat to that, and I don't recall all the case law that I read, but there was a lot of nuance to it. And then I remember there was no case law to it, actually, so we had no way of knowing how the courts are going to treat this. But it was just this big question. It was like, okay, does not prevailing mean that you went forward on your claim and like, do you have to prevail on your sexual harassment claim to collect treble damages? Some attorneys would say yes, others would say no. I personally think that you should have to prevail at the very least. And if it's defeated on MSJ, I think that there's a lot of reasons for that. If you can't survive an MSJ, that means there wasn't a claim to begin with. That means there's no reasonable evidence to suggest that any jury would rule in your favor. That, to me, it's not presumptively bad faith, but it strongly suggests bad faith on the part of Blake Lively. And that's kind of my meandering thoughts as I was listening to the two attorneys earlier around noon after the MSJ. Let me get to some of the stuff. I wrote down a ton of things. Defendant's view negates any subjective perception. Oh, yeah. So the fact that she testified that she was not bothered, that she knew Heath wasn't trying to look at her naked. I know you weren't trying to cop a look. That pretty much negates any subjective perception of harassment and defeats the claim. And all you got to do is get rid of one element of sexual harassment. And subjective is one. Like I don't know what would be the perfect example. If somebody were to call me like I don't know, some derogatory term. I don't want to say anything that's going to offend anybody. Just say somebody's going to call me or I would call my brother something derogatory because we have that relationship, because he's my blood brother. Or you know what? I'll use Lauren 90 as an example. Earlier today, I just made the comment trolling Lauren. It's like, oh, Lauren's fine because Lauren's gayer than my two dogs. There's like people in the chat like Omar, like I feel like I was about to get scolded. It's like, no, it's okay because Lauren's my friend. There were people that would reasonably find that offensive, but because me and Lauren have it, she would not have subjectively been offended by that. And by the way, she's called me much worse. Just like 30 minutes ago, she called me young lady. It's just the nature. It's the nature of our repertoire, or not a repertoire, of our rapport together. You know, reasonable is one thing, subjective is quite another. At bare minimum, you have to have subjective. In other words, it is necessary to have subjectively felt things that makes you sexually harassed, but it is not dispositive of the issue whatsoever. You got to have both subjective and reasonable. Just because you have a reasonable sentiment that something is offensive doesn't mean you have subjective, and one is not the same. You get the point I'm trying to make. I'm not saying that very artfully. I'm going back to like my LSAT studying, and it's giving me flashbacks, and I don't want to do it. There was a point made by one of these attorneys that I think Lauren mentioned something about this guy, that he makes like this weird point. If two male actors are involved in an unscripted kiss, would it violate discrimination law or not because they're both men? And I'm not sure like what the point of that, but that was an example that was made. I guess the argument was that Justin's behavior, even if it was inappropriate, is not inherently gender driven because the same thing could happen between two men. I don't know. It's kind of a stupid example, or maybe I just didn't get it, or maybe I wrote it down wrong. I don't know. Judge Lyman got really animated, according to everybody who saw, about probing the differences between acting and harassment. And he framed it as such, like you're on a creative set. Where do we draw the line? Where's the division between what would be normal film set behavior and unlawful conduct? And if a movie calls for an intimate scene, there's like certain social contracts that exist aside from nudity writers. You're volunteering for this, and there's certainly a script. Presumably you're following a script. I'll give you a really good example of where this might be the case. The one that comes to mind is a Last Tango in Paris. I'm pretty sure that was filmed in 1973. Marlon Brando, I forget the female actress, but there's a scene in that movie where, yeah, it was all scripted. But nobody told this young lady that she was actually going to be digitally penetrated by Marlon Brando. And so when that happened on camera, I forget the director. Who was the director on that film? Was that, I can't think of his name. The same guy that he died like in 1999. He filmed The Shining, Stanley Kubrick. I want to say that Stanley Kubrick was the director on that set. Now, Stanley Kubrick, as far as I know, and I've heard dozens of stories about his extreme measures taken on the set. But here's an example where conduct might be unlawful. It's in the script that Marlon Brando is going to take his actress co-star, and there's going to be a scene where they simulate a sexual assault, essentially. What is not told to this actress is that, oh, no, we're not acting. He's actually going to do that, and we're going to film your raw reaction because you don't know that it's coming, and you're going to do this, and you know, whatever. That could be interpreted as a sexual assault. 100, certainly in 2026, apparently not in 1973. But that's a really good example of where the lines are drawn. You can't draw the line like, hey, we choreographed this kissing scene and his hand fell like 2 centimeters too low or too high, or missed the mark, or kissed me in the wrong spot or whatever, or, you know, was a moment too long or a moment too short. You can't go off of technical violations. Severe and pervasive has to control. Totality of circumstances has to control. We cannot be these trivial minor violations. And if I were to make the point, and I was arguing the point, I would say, yeah, Your Honor, there was an example where we could have drawn the line. Last Tango in Paris, 1973. Marlon Brando is filming a scene with his co-star. They're trying to film a sexual assault. Nobody told this female co-star that she was actually going to be sexually, digitally penetrated. And she was digitally penetrated, to her extreme horror. That horror was captured on film. It was used in the scene in the movie. That would be an example of where we would draw the line in 2026. That's not what happened here, obviously. What Blake Lively is arguing is semantics. We're talking about centimeters of we're talking about centimeters of difference. We're not talking about playing completely different sports. That's the line. That's the line to me. I wrote this quote down. What do we need intimacy coordinators for? Judge Lyman was quoted as saying that. The judge zeroes in on severe and pervasive. If defendants can knock, he goes in, if defendants can knock out any one sexual or element of sexual harassment, then judgment in their favor. So he's talking about this, and he's going on about this, and he's saying that, look, if you knock this out, then you're going to win. That to me is signaling that my wife is like filming me or something. She's pointing her camera at me. Oh, it looks like she's pointing her cameras like, hey, someone else is taking pictures. That would be an example of something that's not scripted. Oh, is that the female actress? Oh, it was not. I apologize to Stanley Kubrick. He was not the director of Last Tango in Paris. Oh, I got to read my chats. So Justin can sue Blake for SH and actual SA. Well, I don't know about that. That I don't know. What chat should I read? What did I miss? Oh, Bernardo Bertolucci. Yeah, Last Tango in Paris. That was not Stanley Kubrick, I guess is the point. Heated rivalry. Here's one. If Blake is successful in arguing that an empowered forehead kiss is SH during the making of a film, then Baldoni should be able to sue her for SH for her improvised touching, kissing, lip biting. Yes. Because my recollection of that scene and the filming of that scene was she was way more off script than he was. But he didn't bring us. And you know what? If he were to bring a lawsuit for SH, it would fail because he did not feel subjectively harassed, did he? And if he did, maybe he has a claim. But he never brought that. And you know what? To that degree, neither did Blake Lively. There's contemporaneous aspects of this. Like it happened in the moment, and you said nothing, and you waited until an opportune time to make these allegations known. You didn't even go through the proper channels to complain, like through HR or go to Sony or whatever, or file an official complaint, an administrative complaint. You basically had these allegations lying in wait for a time that you felt you could profit from. That seems to be bad faith, regardless of whether or not Justin Baldoni has an existing cross complaint against Blake Lively or not. It's certainly problematic with respect to her sexual harassment complaints. MCH Life with the 5 says, this super chat is for Lauren. We love you for being so honest and transparent, but also love Omar. Well, thanks. I will give $5 to Lauren as soon as I see her. Next. Winks and Wilts with $50. Thank you so much. I just want to say we appreciate your coverage and everything you do, Omar. Thank you. And I appreciate all of you. Thank you so much for that. You didn't have to do that. I feel so humbled by this super chat. I don't know. It's been a kind of a crazy week. I've been doing like these experimental political streams. I've been feeling a certain way about it. I'm going to have, for all of you that are interested, I will do a rehashing of the debate I did with Nick Rekieta the other day. I have a lot of thoughts about it. I'm disappointed and I'm encouraged by a lot of things, but I'm not going to talk about that tonight. Let me get to... This is the problem when I go by myself. I go all over the place. I've lost my place. I'm trying to get through my notes of what Lyman was saying. Oh, there's a line of questioning. Well, Lyman was pressing counsel about the subjective element. We kind of talked about that. He agrees that harassment law requires the conduct to be based off of a protected category. He notes skepticism that Baldoni's onset behavior was because Lively is female. And I guess that was the reason for the two. What if it was like Brokeback Mountain and the same kind of a thing? I hate that example. It doesn't show me any proof that this was gender-based, you know? I don't know. I need some better evidence. Show me that he was targeting women by doing anything to you that he did in this scene. Show me anything that he's done to you that you didn't equally or to a greater degree do to him. I'd like to see that. I got this quote, may go to whether it was based on sex if it only happened to women, but it cannot go into whether it was severe or pervasive for Blake if she didn't know about it. That's the subjective element. In other words, even if there's stuff that you want to argue about gender-based sexual harassment, if Blake didn't know about it, then it doesn't even matter. We don't even get that far because who cares? She was not subjectively sexually harassed. And so therefore your claim fails. I don't know, man. I feel like this is a slam dunk death by motion for summary judgment for the sexual harassment stuff. They talked about, what was the evidence that they acknowledged? There was, well, obviously the deposition where she acknowledges not feeling violated. There's no subjective harassment at that point. They talked about an exhibit where the Wayfarer attorneys were trying to pin down her contemporaneous reactions, or basically the lack thereof. So when he did this, how long before you like made it a thing? So this happened when, and then, so right immediately afterwards, you must have lodged a complaint. Oh no, you didn't lodge a complaint. So when did you lodge a complaint? Oh, you never did. But well, I guess until the CRD in December 31st, 2024, correct? But this all happened like months prior to that, like basically over a year before that. Get the fuck out of here. This is where we're going with this. What did they use from Justin's deposition? My notes aren't exactly clear. Oh, there was a talk about Judge Lyman was really familiar with all of the evidence, and he was asking Lively's attorneys about specific stuff in their exhibits, and they were struggling trying to find it. That was my takeaway. But it seemed like the Wayfarer attorney that was arguing had it all down to page, line, and was able to reference everything like on the spot because they knew his stuff. And sometimes when you have a winning case, it's like that. And when you have a losing case and you don't just, it's a slog to look at this stuff. Sometimes that happens. They talked about a text exchange between Lively and Jenny Slate on January 14th. What was that about? Oh, trying to show that Baldoni had a pattern with women, but Judge Lyman was dubious as to that claim, especially if Lively only learned about it later on. So then how was that a hostile work environment? She can't complain about a hostile work environment that she didn't know about, was I think his point. Basically, my take on it is this. I think that Judge Lyman is inclined to grant summary judgment for the defendants on the sexual harassment stuff. The questions that he's asking go strictly to the core elements of sexual harassment, and I don't think that they have anything to say on how to cure it. He's zeroing in on, look, I need to find the elements. And really for MSJ, all they got to do is show me a modicum of evidence that you were subjectively feeling harassed at the time that it happened. So show me any evidence that you felt sexually harassed, like for example, when Baldoni took certain liberties during the filming of intimate scenes. What did you do? Who did you tell? Did you text somebody? Did you call somebody? Show me the evidence that says that later on that night, approximately 45 minutes later, I called my mother crying and unsure what to do with myself because I felt like I signed up for one thing and then Justin Baldoni did something completely different. And I've never been more embarrassed in my life. I've never felt more violated. I don't know who should I do. This is all a big movie set, a big Hollywood thing, and there's millions of dollars to be made. I don't know where to go or who to turn to. Show me any evidence that you did anything of that nature to anyone. Did you tell Ryan Reynolds? Did you text him? Did you call him that night? Did you file an HR complaint with Sony or through the appropriate channels? Lodging your displeasure. I know you wrote this 17-page thing or this 17-point letter. Great. But how far after the violations did that happen? And what were you getting out of that 17-point letter? Because it seems like that 17-point letter about the things that you wanted everybody to bend to for you to continue working on the set was geared towards you having a more comfortable work environment, and you were kind of coercing them into agreeing with you. If those were legitimate sexual harassment complaints, why did they not occur immediately upon happening? Look, Blake Lively is not like an extra on the set. If she subjectively felt violated, she could have went to her husband. She could have went to any of the producers and said, I'm off. I'm not doing this. Baldoni, what he did to me is bullshit. I need another co-star. I am the victim of a crime. But the way that she went about it, the problem that she's having is the same problem that we've all been talking about for so long. It really appeared that she was leveraging these sexual harassment allegations because she understood Justin Baldoni's reputation to be what it was, for one, which was he's this good guy these champion of women rights. He's done these TED Talks trying to promote or speak against or to promote feminism and to speak against manliness or machismo or the manosphere or whatever it was. And she was threatening his reputation in that way, specifically because if you allege sexual harassment like that guy, then you will ruin him in the industry. Aside from the fact that I'm sure there's been, well, we hadn't even gotten to the evidence about Ryan Reynolds going to all of Baldoni's employers. Some of that is in Justin's depositions where he says, like, yeah, I was terrified of Ryan Reynolds. He's going to all my employers and telling them I'm this bad guy or I'm this or I'm that. I was terrified of what they could do to me. They literally just stole my movie. If they could do that, they could do anything. Who's saying stuff like that? It just really, what this looks like is pure retaliatory sexual harassment allegations. It does not look like bona fide, legitimate sexual harassment. It does not. As to retaliation, what do I got here? Lively pointed to a protections memo that was issued on set in November of 2023. After she raised complaints as the trigger, she claims her on-set complaint put the defendants on notice, and then they later retaliated. But then they kind of deviate from that, and then she says, well, actually, Lively's refusal to be publicly associated with Baldoni around 2024 was because of stuff that was coming out around then. And it was like, you can't have, okay, in your complaint you said one thing, but now we're basing it off of conduct that Baldoni was engaging in behind the scenes around the film's premiere in July of 2024. The specific allegation was that Lively declined to take photos with Baldoni or attend the premiere if he attended because she was viewing him as a harasser. I guess he was conspiring with all of these people. And then there was a comment that they kept saying that, well, I mean, if his plan was retaliatory, and then there was another text message saying that I didn't know that he felt that way. I'm never going to talk to him again. I guess it didn't work very well, did it? There was that issue. What else do I got? So Wayfarer basically argues that Lively can't establish protected activity. They can't establish adverse action. They certainly can't establish a causal link. Those are the three essential elements of retaliation. They contend that Lively alleged complaints were not made through proper channels. That was the obvious one, right? Judge Lyman hones in on this point. You're not arguing by telling the press that Baldoni sexually harassed her. That's protective activity, right? And they concede on that point. Plaintiff's counsel concedes that external publicity is not protected. To be protected, a complaint must be made to the employer or an authority that can remedy the issue. And that's how they got in the whole discussion. And like, so then what are we doing with the FEHA stuff? Because we can get more damages, all right? There was a remark that many months had passed after the November 2023 on-set complaint, during which Lively continued working amicably on the film and indeed finishes the film. And then obviously the obvious argument after that, and we kind of read some of those in the some of that in MSJ, was that kind of breaks the causal claim. If she has these demands in November of 2023, and then we're fine up until July of 2024, what's the causal link? There's no retaliation here. What were we doing? We were making a film when we did make the film. Whatever her whims were, whatever her demands were, including taking editorial privilege of the film, was granted to her. She was given carte blanche basically to do what she wants. She essentially, and for all intents and purposes, stole the film. How could you argue otherwise? And so then where's the causal link between anything that Justin did and something that he was supposedly and allegedly retaliating for? If his retaliatory conduct happens in 2023, then you can't then claim that those actions were retaliation for something that occurred in 2024 for one, but they try to make those points is what it sounds like. I put in my notes that they pivoted. They're trying to focus on the premiere as the new protected activity because that was close to the alleged smear campaign. And then the defense is like, Lively's premiere boycott was not a lawful complaint. It was disruptive demand, unrelated to any formal harassment report. They characterize it as Lively attempting to exert leverage. Of course they did. And so, in other words, there's no causal link. There's nothing. If the remark was, what did he do to retaliate? Well, he goes to these publicists to try to spread bad publicity about Blake Lively. And the response that he got to that was, they're never going to talk to him again. Where's the rub? And so that was that. Judge Lyman zeroes in on what exactly Lively did that law would recognize as protected and that consequent harm she suffered. His question suggests skepticism on both fronts. Yeah. And then the quote, too much time has passed. That breaks causality. And I agree. I agree with that. Too much time has passed, breaks causality. There's nothing there to suggest retaliation. So that's it. As far as sexual harassment goes, I just think it's out. I just think it's out. How much time have I spent on this? 56 minutes. I got a little bit more here. All right. House of the Chatter podcast with 5. Does it matter in the CRD that Lively claims this is a new form of retaliation? I'm down to collaborate. Sure. Shoot me an email. I'm a tiltedlawyer at gmail.com. Well, if it's a new form of retaliation, there's got to be some backing in terms of public policy then, right? Sure, you could claim a new form. You could claim, I guess the retaliation still has to meet those 3 elements, right? It still has to meet all the elements that make it retaliation. You could claim that this new form of retaliation meets these elements because there's no case law on it because, fine. The problem is you still have to tie it into some direct conduct on the part of Baldoni, some causal link, some overt act that he did to retaliate against something that she did. So if you say that he's retaliating because of the 2023 July letter or January, whatever date it was, but the retaliation occurs in July, well, that doesn't make much sense, does it? And that was the problem. The Judge Lyman was having. It was just like, you can't connect any one thing that he did where he successfully retaliated against you against something that was effective, that was something that you did that was protected speech that fits here. And the best that they could come up with was stuff that happened at the premiere, and Judge Lyman was unimpressed. And so based off of that, I don't think Judge Lyman is buying it. And based on his willingness to dismiss things, at least at the 12B6 motions against Justin, he dismissed things for much less. I think that there's no retaliation here. The sexual harassment stuff, I just feel like it's dead in the water. The way that he's talking about it, the questions that he's asking, it doesn't feel like he even gave them so much of a bone. Like he wasn't asking them anything, and they were able to give some satisfactory answer that quelled or at least appeased his concerns. There was some argument back and forth about case law. I don't know specifically what case law they were talking about. They didn't have the 2 lawyers. It's easier to say the 2 lawyers than not actually Golden and little girl attorney every single time. So the 2 lawyers, they didn't have the case site of the thing that they were talking about, but there was something where Lively's attorney was like, look, you could do that if you want, Judge, but there's no case law to support what you're saying or whatever. Maybe. I don't know. I just feel like Judge Lyman is not buying the retaliation aspect of it. He's looked at all this evidence, and really what it is, and they kept on going back to this. Every single time Blake Lively wanted something, she got it. Every time she made a demand, there was a concession. Every time there was a concession made, it was to Blake Lively. So what is she complaining about? What was the specific time? What is this smear campaign that she's talking about? So he had conversations. He sent text messages to publicists or to news folks to write bad press. There's no proof. There's been no proof that I've seen in anything that's been presented that links something that Baldoni said that led to some negative press that couldn't also be attributed to, hey, people had questions about Lively, or maybe Blake Lively's just being a cunt. Or maybe she's like, there's a lot of bad press floating around her. There's no proof to suggest that it's because or on account of a smear campaign. that was navigated or started by Justin Baldoni. So there's that. House of Chatter, shoot me an email. We'll collaborate. We'll come up with something. I'm 100% down. Lost Coke. Thanks for cutting through the bullshit. I try. I can't say bullshit anymore. I have to say sugar plums. That's the rule anyway. My daughter's got that from the movie Elf. Said, Dad, every time you say a bad word, you have to say sugar plums. What? Oh, the Grinch. It's from the Grinch. It's not from the Elf. It's from the Grinch. Well, hey, it works. If you say sugar plums, you actually get it out of your system and it sounds nicer, you know? Hey, Don't F for Justice is here. Yeah, sugar plums. Sugar plums. That's the new, when I say sugar plums, just know that I mean bullshit or whatever other bad word you want to attach to it. A smear campaign that's never been done before. Exactly. That's the issue with her case. Let me see if I could get through some. My notes are all kind of scattered. I wish that I made more sense. As to the defamation stuff, what do I got here? Allegations was that defendants, through their agents and PR teams, defamed her as part of the above-mentioned smear campaign because of false statements to the media, Hollywood community, portraying Lively as unprofessional. There were people talking about Lively being unprofessional, unprovoked because of her failure to appear at things with Justin Baldoni. Now she's going to claim, well, I just didn't feel comfortable being around Justin Baldoni because he was initiating a smear campaign against me. Well, if you do that, you know, some people might consider that without knowing the context of it is unprofessional. And maybe they were like, hey, it's kind of unprofessional that now's the time to promote this film and Baldoni's going out here and you're leaving him here on an island and people are expecting to see you guys together. It's really unprofessional and kind of shitty that you're not all in on promoting this film. Or maybe we could consider that your unprofessional behavior is costing everybody involved with the film millions of dollars potentially. Did you ever think about that? I think that that's a thought that somebody might come to organically without knowing anything about her thoughts or attempted coercion of sexual harassment against Justin Baldoni. How about that? Suck on them sugar plums. Oh boy. What else we got? She points to articles, some that appeared late in 2024 that contain negative claims. So what? Talking about Lively was difficult on set, that she was making unreasonable demands. Well, it appears like that's all true. All of that is true. Based on all of the prevailing evidence, and she's not even really denying it. There hasn't even been she's never denied that she made demands. Matter of fact, at the heart of her case in chief is her 17-point list of demands. And so if truth is a defense to defamation, then what is the smear campaign there? If that's the thing that was leaked, that Blake Lively was making demands, I failed to see how that's defamatory if it was true. I mean, obviously that's not the crux of her argument. I'm just thinking out loud. She feigned illness to avoid stuff. She maintains that those accusations are false, are disseminated maliciously by defendants to salvage their own reputation. There was one key contention about whether characterizations of Lively's conduct are actionable. Obviously, Lively argues that they were crossing lines by making provably false assertions. For example, if Wayfarer representatives told reporters that Lively breached her contract and that no one wants to work with Lively because of her lies, these would be concrete defamatory statements. And there was some argument as to maybe libel per se. I wrote in my notes. The Wayfarer parties basically have a different opinion. Go figure. They claim that Lively, number one, defamed him, obviously because there was the cross complaint. There's not a pending cross complaint, but obviously that was one of his assertions that, look, if there's any retaliatory allegations going on, I'm the one being accused of sexual harassment here. An accusation that has now been widely published and has been publicized by virtue of an infinite number of media outlets. There was some discussion about the separate counterclaim or whatever. They had brought up the defense of truth. They are maintaining that the statements that were made, if any, were true statements that they made or their proxies made about Lively. They were substantially true and certainly not knowingly false. For example, if they told the New York Times that Lively had demands that got to the point of absurdity or that she tried to leverage her position for creative control, defendants would argue those statements have a factual basis. And they talked about another defense being that some of the statements are non-actionable opinion, and that's true. If Ryan Reynolds could get away with calling Justin Baldoni a sexual predator, then why couldn't Justin Baldoni get away with calling Blake Lively a cunt? A demanding yeasty, mealy cunt, in my opinion. Obviously, I'm taking it too far. I am just saying, some of the stuff, if it's opinion, it's non-actionable opinion, it should not be the subject of defamation causes of action. Judge Lyman homes in on this distinction. There's a discussion about fact versus opinion. They talk about mixed questions. For example, calling someone difficult or saying we've bent over backwards and this is insanity can be seen as hyperbolic opinion, not a verifiable fact. Defense counsel probably asserted that Baldoni's statements responding to Lively's claims were privileged, protected speech. Either way, it seems to me that the defense is stressing that actual malice, making statements with actual malice, is an extremely high bar. And if the complaints if the defamatory statements that they're talking about have to do with her being difficult on the set or difficult to work with or making outrageous demands, even if it's hyperbole, even if it wasn't literally true, getting to actual malice is a really high bar. And so there's a couple things working. I don't know how you could have a 17-point list, the text messages that are going back and forth, and all of these exhibits that have been submitted with the MSJ that demonstrate all of the demands that Blake Lively made, all of the concessions that were made on account of her, all of the changes that she demanded on set, changes to wardrobe, changes to filming location, changes to filming times, 17-point list. Ryan Reynolds is now for some reason involved and is yelling at Justin Baldoni. Herself taking liberties in the filming of intimate scenes with Justin Baldoni while complaining about him not strictly adhering to some script that was supposed to be had out. If all of those things are inherently in the evidence and the defamatory statements are she was difficult to work with, I don't know. I'm buying the non-actionable. I am buying the non-actionable opinion angle. I don't see malice in that. Malice would have been something akin to, look, I know that she's trying to steal my movie. She's trying to steal my movie, and I could prove it. I know for a fact that she's trying to set me up for some bullshit sexual harassment complaints, and just wait in a couple of months. If you hear something about sexual harassment against me, just know it's all bullshit. I know she's doing this because she's going to try to steal my movie and turn it into a franchise and rob me of my movie. If he had said stuff like that and presented it in that way, that could potentially be actionable. And he had reason to say those things. He had, it turns out, in his deposition, had suspected that kind of thing was going on. But he didn't say that. He didn't really say much. She was difficult to work with. She made demands. It was a difficult filming environment. All of those things appear to have been true. And I'm not even sure that Blake Lively is disagreeing. I mean, she's disagreeing for the purpose of this MSJ. But you cannot, with a straight face and in good faith, deny the truth of those statements with the evidence that exists, that has been submitted on MSJ, with the things that she said in depositions, with the lists that have been provided as a part of the pleadings. You just cannot. You can't. And so, what did I write here? Judge Lyman's approach to defamation issues was analytical, focused on the law. He's keen to sort the statements into categories: fact versus opinion, privileged versus unprivileged. There's a point during the defense's argument that judge raises the question of whether Baldoni's statement were legally protected. I wrote 6 inches away for some reason. I don't know what that means. Oh, I will get to it. I'm trying to make sense of my notes. A reference to, I don't know. I don't know what I meant by that. What was the 6 inches away thing? He's paying really close attention to statements about whether or not they were pure opinion. What else did I say? They said that Lyman seemed disciplined to let marginal defamation claims through to a jury if they hinge on statements that are arguably opinions about a contentious business dispute. He observed the context. The case is highly public. Both sides are engaged in media battles. He's hinting at a view that some harsh language might be seen as rhetoric, and he said that before. And all you got to do to figure out what he's thinking there is he allowed Ryan Reynolds to say that Justin Baldoni was a sexual predator without penalty, even though the term sexual predator has a legal connotation to it, because sexual predator necessarily attaches as a legal conclusion to those who have been convicted of sex crimes. Not only you're a sexual predator, but you're required to then register as a sex offender. And sex offenders are sexual predators and vice versa. If you could say that and have this judge think it's opinion, then the statements they are alleging are defamatory. I cannot for the life of me reason why Judge Lyman would not kick those out for just being hyperbolic opinion at best. And so to that regard, I think that's where the defamation claims are going to die. What do I think about Lyman's, what's going to happen with the defamation claim? If they're not kicked out entirely, he may leave them in for the narrow purpose of trying to, if he thinks that a reasonable jury could view those statements, well, here's what I'm trying to say. If he thinks that the question of whether or not the statements made against Lively, the defamatory statements, can be reasonably found by a jury to be defamatory, then he's going to let it in. And that means that he thinks that no reasonable jury, or he thinks that there is a reasonable jury that could look at those statements and say that, yeah, that's not opinion. They didn't have to say that. They said that because they were mad at Blake Lively for various different things, whatever. They said it maliciously. That would be the standard. I just don't see it the way that he was questioning, in the way that he was questioning the attorneys and the way that the responses came back to Judge Lyman. There's just not much meat on that bone. And so in an effort to whittle this down, I think sexual harassment is going away. I think defamation is going away because it's stupid. If Justin Baldoni's defamation complaint didn't survive 12v6, I cannot for the life of me understand how Lively's defamation complaint against him is going to survive. That would make no sense. That would be incongruous with what we've seen from Judge Lyman in this very lawsuit. And so there's that. I'm not going to talk about spoliation of evidence because, to be honest with you, I kind of tuned out and zoned out in that and didn't take much notes on it. I know they talked about it. Most people don't care. We will see as to that. There's some contract stuff, and they did talk about that. I don't want to bore you guys too much with that stuff. Here's what I predict with all of this. And I think what I said in Lauren's, like verbatim, what I said in Lauren's stream, I predicted sexual harassment is out. I don't remember if I said defamation is out or not. I don't think I even referenced it. I basically said sexual harassment is out. The contract stuff is in. And then the party is going to decide that, you know what, the contract stuff is not worth it. They may have a motion on 47.1 about what happens to the 47.1 treble damages if the sexual harassment claim doesn't survive MSJ. And if so, and if it's completely out, then I think they're just going to settle this. And if we're arguing about breach of contract, then who cares? Maybe. That's my prediction on that. And with that, I think I'd probably be better served answering or like trying to look at the chat as far as like, instead of trying to make sense of my notes that I took from like 12 hours ago. House of Chatter says, do you know if disclosing a medical condition to a personal trainer is covered under HIPAA laws? Well, it depends on who is disclosing it, I guess. Like, if you're going and telling people your medical stuff to the point where they could then like recite it to somebody else, I think you've kind of waived your own HIPAA laws, you know? I think she's going to be all right. Or I think Justin's going to be okay with that. I'm just not worried about it. I could be completely wrong on that. I'm just pretty sure that I'm not. I'm pretty sure that if you disclose your own medical information, you've waived whatever HIPAA protections. Like I've seen people do it in court where they volunteer, like, look, judge, I have cancer. And then they'll give all their medical documents to the bailiff and hand it to the judge and hand copies to the attorneys. And then you can't not go back and then say that, hey, you can't talk about medical stuff. HIPAA protections. Like, bitch, you just waived it. It was a guy. I'm not, you know what? I shouldn't have said that word. Sugar Plum, you just waived your HIPAA protection. You cannot then claim you're protected under privilege, whatever. I think that's kind of the way that works. Less relevant in the personal trainer scenario. I just can't imagine a world where anybody's guilty of any kind of HIPAA violation on account of that. Would be my off-the-cuff take. Parky Posey with the 279. By the way, that's a pretty specific number. Does Blake have anything going for her in case? I mean, no. If you ask my opinion, I don't think that her entire complaint is getting kicked out on motion for summary judgment. She may have stuff going for her for breach of contract stuff, but she didn't sign any contracts. And so I don't think that she's going to prevail on the merits. And if you ask, but if by what you mean by that is, does she have anything going for her? Like, is she likely to win on anything? I don't see it. I don't see how she prevails on any breach of contract cause of action if she didn't sign any contracts. And if we're going by the conduct of the parties, because I've been saying up and down for like a year now, that just because you don't have a signed contract doesn't mean that you don't have a contract. We could figure out what a contract is. I got to tell you, like some of my very first contract cases as a young lawyer were based on oral agreements where we had to talk about, look, there was promises made about money. Okay. There was even stuff that's not enforceable unless it was a contract that was written. In other words, if the contract's not in writing, then it's not enforceable, except there's equitable principles, meaning that if somebody's been unfairly unjust because the parties acted like they thought they had an agreement and one party availed themselves of the promises of another that weren't kept and therefore disadvantaged themselves and unjustly enriched another person, then the party in principles of equity will form a contract, even where one doesn't exist, because of equitable, in other words, to make it fair, in the simplest terms. And that's why people hate contracts, because none of the stuff seems to, well, it's not, you don't have a contract, you didn't sign it. Well, it doesn't matter, we could find a contract. But nobody signed anything. Okay, but you made a movie and you did that for consideration and valuable consideration at that. You were paid a sum of money. There was a set schedule. Everybody on set seemed to believe that there was something going where we're making a movie. There was certainly a contractual objective, and you performed a contractual role, even if not in writing. There were certainly contracts that weren't drawn up, even if that there were certainly contracts that were drawn up, even if they weren't signed. We can use that as a framework for what the parties may have intended. And because they weren't signed, we have every right to adjust those terms based on the conduct of the parties. And in that way, we could analyze the concessions that were made to Blake Lively while on set by Justin Baldoni and other producers on the film and on the set and whatever. And we could figure out who's in breach of what. If you ask my opinion, I think that if someone were to prevail on a contract breach cause of action, I would have put more money on Baldoni's side than Lively's side, only because of all the concessions that were made against her. I think he has a better argument by simply stating that, look, we went into this with the best of intentions. We thought she was going to sign the agreement. It's pretty standard that people sign agreements, but we were on a strict film schedule, and we were going to we detrimentally relied on the promises made by Blake Lively, and she showed up on set. We had to get the film made. Putting this off or delaying was not an option because it was going to cost us hundreds of thousands of dollars. And every single time we were threatened with being thrown off of schedule because of Blake Lively's demand, we had to concede. We were coerced into conceding. And therefore, based on the understandings of the parties, she is in breach because she broke her promises, and we were forced to comply with her demands. Otherwise, we would have never got the film made, and we would have been out however many millions of dollars in investment. That to me is a stronger argument than Lively trying to argue breach of contract when all the concessions that were made appeared to have appeased her. So that's a long-winded way of saying that, no, I don't think Blake has anything going for her in this case. Not on the merits anyway. She might have some stuff to survive MSJ, but I don't think there's anything she's taken to a jury and winning. That's my answer to that. The unsolicited opinion, I love that name, with the 10, says, so if Blake's case is tossed in total or parts, what opinions are there for Wayfarer parties? Oh, what options are there for Wayfarer parties to recoup? Well, they could recover costs of suit. If they go all the way to trial and they win, then they have every right to ask for the cost of the lawsuit, and that could be millions of dollars in attorney fees and costs. Someone had asked in the chat what I thought the attorney fees were. There are so many attorneys on both sides. We're not talking about like, somebody with a private practice representing a client, where you could expect a lawsuit to cost maybe $100,000, in total for like a year of litigation on a conservative estimate. You got teams of attorneys and paralegals. Every single one of them attorneys and paralegals are billing individually. You can very rapidly rack up millions of dollars in charges. Just looking at the docket is exhausting. Every single one of those pages have to be read and disseminated and redacted and highlighted and marshaled and briefed. Legal research out the ass. I mean, I don't see a world where both sides haven't racked up at least $1 million a month in legal fees and costs, which I would estimate that Blake Lively is probably racked up 12 to 20 million in legal costs and fees. I can't imagine a world where Baldoni hasn't racked up a similar amount. And so if Wayfarer prevails on the merits at trial, if they are forced to go through with this trial that I guess is taking place in May, no longer in March, then yeah, that would be the thing that they move to recoup. That would be the way to do it, which clearly it's not chump change. Now, could they potentially settle and just mutually agree to walk away? Sure they can. Are they going to do that? It's my guess that they're going to do that. I don't know what they're going to do. I just think that if the breach of contract is all that's left, Blake Lively is going to try really hard to settle, just because I don't see a world where she prevails on a breach of contract cause of action where she didn't sign any contracts, and every concession made in whatever verbal agreements or whatever equitable contracts the court finds were to appease her. I just don't see where she prevails. That's my opinion. That's what I think is going to happen. What do we got? Lemon meringue 43.92 with the 129. I apologize for my ignorance. I don't know what SEKs are. Sec? I don't know what secs are. I know what this sounds. I don't know what a sec is. I'm sorry, but thank you so much for that. Now that we've seen the evidence, should have Judge Lyman have thrown out the defamation case? What do you think Judge Lyman thinks now? Well, it's like I said, he threw out Baldoni's defamation cause of action for significantly less. And I forget the specific reasoning, but it was something similar. It's like, look, on the Ryan Reynolds stuff, called you a sexual predator. He classified that basically as hyperbolic opinion. It was non-actionable. It was his opinion. He didn't like you. He said mean things to you. That's not defamation. You can't connect it. You can't prove malice. And malice doesn't mean that you didn't like. In other words, he couldn't prove malice because malice doesn't mean simply that Ryan Reynolds didn't like Justin Baldoni. Malice means that he said it for some kind of financial gain. And that would mean that he would have to prove that he called him a sexual predator and in some way benefited from it by stealing something of value from Justin. And you could argue that might have been his intent, but there's very little proof to prove that. And he kicked it on a 12v6. At least I think that's what I remember of my analysis from like 6 months ago, whenever it was. That's what I remember. That's my memory of what Judge Lyman's reasoning was. Here, he's kind of saying the same thing, and he questioned him on the same thing on the motion for summary judgment. Is this defamation? Is this defamatory? Is he saying untrue fact, or is this hyperbolic opinion? I need to know the distinction. He's going down that same line of reasoning. He's being very consistent there. And based on what Lyman said in his 12v6 opinions, he has to kick this one out too. I just don't see. I don't see a world where the defamation claims survive based on Lyman's logic from the 12v6 stuff, however many months ago that was. And so that's what I think of that. Aquanetta with the 50. Thank you for all you do. You always have my support, Omar. Much love. And much love to you as well. Thank you so much. Aquanetta has been a member of my channel. She's been coming to these streams pretty much, as I recall, since I started covering this lively stuff. She's one of my favorite listeners, subscribers. What would be the word? Content consumers. She's one of my favorite people. I would see her in the chats. I appreciate you greatly. Juicy Pruse says, if they settle, could Blake Ryan come back? If they settle, could Blake Ryan come back and sue for something else? No, they cannot. What legal protections are to prevent this? Well, if they settle, I'd imagine there's going to be, they're going to dismiss this with prejudice, meaning nobody is allowed to bring a claim or any cause of action related to this incident. This incident meaning everything that happened during the filming of this set, any cause of action that could have been brought during this portion of the movie or in this cause of action or whatever. Basically, whatever it is that you could bring, you can't bring it in the future. They're going to agree to that. If they settle this complaint, there's going to be a mutual agreement such that they cannot do that. Plus, there's going to be, I believe, with Justin Baldoni, there's he's already had one bite at the apple. He lost his complaint on 12v6, and it wasn't voluntarily dismissed. It was dismissed because of 12v6. And so I believe without prejudice, but you know what? I'm overthinking it. When they settle, there's going to be language in the contract that says that nobody can sue anybody else for anything that happened or could have been brought in this lawsuit going forward. End of story. That's it. And there's probably going to be non-disparagement agreements. There may be stuff saying we can't talk about this lawsuit. There's going to be stuff like that. That's how they're going to get around it. Parker Posey with the 279 says, when do you think the rulings will come in? I would imagine a couple of weeks. He's going to take, why not? Take 2-3 weeks. How long did he take with the 12v6 stuff? I feel like it took like about a month. I remember it so long ago. I'd imagine that he's going to sit down with this and really just, it's going to be a really long opinion. Little girl attorney and not actually Golden said that today, and I agree. It's going to be the way that they were describing how he was zeroed into the case law in this case. It really feels like he's got a lot to say, and he's going to frame the opinion in such a way to try to prevent any kind of appeals. And so he's going to, do all of his research and make sure everything is checked. And I wouldn't be surprised if he took 4 to 6 weeks, honestly. So we'll see. He's not in any rush. We'll see. Redondo Beach. How you doing, young lady? Damage done to true victims is unforgivable. And that's kind of the anger with this case, isn't it? With I don't think anybody would care about this case if Blake Lively wasn't going about on these PR tours and getting awards for being this person of great courage, representing victims, female victims everywhere against the prevailing dangers of being involved with men, and trying to go after a guy that, by all accounts, has been this upstanding citizen. That's the guy she's going after, and she's trying to call herself this survivor of sexual harassment based on all of that, all the stuff we talked about in the complaint. It is. It's a slap in the face to people that genuinely deal with these issues every day. And I certainly understand the anger, and I get it. Michelle 323 with the 5. Is there any chance Blake can just withdraw now for her mental health? No. In order to dismiss the complaint, she would have to get the other side to agree. And if she wants to dismiss, I guess they could conceivably mutually dismiss. And if that's the case, then it just goes away. But they ain't doing that at this point. I'd imagine they're going to want a crack at their own attorney fees and costs. If that's the way she goes, she's not going to approach it that way. They're just going to probably request like a walkaway settlement. Look, you walk away, we'll both pay our own attorney fees, and that'll be that. And I imagine that the crux of the negotiation is going to be on how much either side is going to be responsible for the other's attorney fees and costs. But I don't see the Wayfarer parties just walking away without trying to be compensated for their attorney fees and costs, at least a certain amount. But yeah, she can't just voluntarily walk away and just leave this where it is. Not in its entirety anyway. She could dismiss certain causes of action, I believe. I don't think it's too late to do that. But the fact that we've gone this far in litigation, the other side is still entitled to their attorney fees and costs. And so there's little incentive to do that. Why would they do that now? What's the point? If they were going to do that, they should have done it very early on, perhaps when they were amending their complaints and trying to get all their facts straight, but they didn't. So the fact that we've been litigating for a year, no, there's no scenario where she could voluntarily dismiss not just her entire lawsuit, like not even a singular cause of action, without facing some kind of repercussion. Unless, of course, the parties agree and they could agree to do whatever they want. So that's how I'm going to answer that. Folks, I've been going for 90 minutes, and I think I'm going to leave it there. Thank you so much for hanging out with me and discussing this MSJ. I promise I'm going to get through some of the unsealed evidence, because we're going to have time. Now that the MSJ is under review, we might as well go in and do a deep dive on some of the evidence. I think that's going to become some of our upcoming shows. I was going to do the thing tonight with Cassidy, but she probably just fell asleep, honestly. It's really late for her. So we'll do that another time. But folks, thank you all for coming in and hanging out with me, all 1,200 of you. I love you all, and I will see you guys next time. Bye-bye.